Welcome to the deep dive. Today we're tackling something really central to how our global economy works. Intellectual property rights and how they're handled across borders.
Well, a big topic, definitely.
Yeah, and we've got some key sources lined up. There's a TRIPS agreement that's kind of the main event for trade-related IP.
Right, the big one.
Plus we'll pull in bits from GATS on services, JTT 1994 for goods, and even the older foundational texts like the Berne Convention for Copyright and the Paris Convention for Industrial Property.
A good mix. Our plan is basically to unpack these, pull out the key insights on how these international rules protect things like inventions, brands, creative works, and, what that actually means for trade.
Exactly. Think of it as trying to get a solid handle on a complicated subject fast.
We're talking copyright books, music, software trademarks, those logos and brand names we all recognize.
Geographical indications too, like, champagne or Stilton cheese.
Yes. And patents, of course, for inventions, industrial designs, even the layout of computer chips.
And don't forget trade secrets, that crucial hidden knowledge.
Right, the undisclosed information. We'll also touch on how these rights get enforced, what happens when countries disagree.
So yeah, if you want to grasp this area without reading stacks of legal documents, hopefully this deep dive is for you.
Okay, where should we start? The basics.
Let's do it. Foundational principles first. TRIPS seems like the place to begin.
Sounds good. So Article 1 of TRIPS, it basically says member countries have to implement the agreement's rules. It's a requirement.
They have to put it into their own laws.
Exactly. Now, they can choose to offer, stronger protection if they want. That's fine. But they can't go below the TRIPS standard or contradict it.
So it sets a floor, not a ceiling.
That's a good way to put it. It establishes this common baseline across almost all the world's trading nations.
Okay, common standards, but with some flexibility. Now, when TRIPS talks about intellectual property, what exactly falls under that umbrella, according to the agreement itself?
Well, Article 1.2 points to the different sections in Part 2 of the agreement. And essentially, it covers all those categories we just listed off.
Right.
Copyright, trademarks, geographical indications, patents, industrial designs like those chip layouts, and undisclosed information trade secrets. It's pretty comprehensive.
Got it. Covers the main areas that matter for trade. Now, one principle that keeps popping up is national treatment. What's the core idea there?
Ah, yes, national treatment, Article 3. It's absolutely fundamental. The basic idea is that each member country has to treat creators and IP owners from other member countries just as well as it treats its own citizens.
No special favors for the home team.
Exactly. So if, say, a German company owns a patent in Brazil, Brazil has to give that German company the same patent rights and protections it would give a Brazilian company.
Okay.
It stops countries discriminating against foreigners, which helps level the playing field for international business.
Makes sense. Crucial for fairness. But who counts as a national of another member? That sounds like it could get complicated.
It does have layers. Article 3.3 clarifies this. TRIPS actually points to the eligibility rules in other big IP treaties.
Like Berne and Paris.
Exactly. The Paris Convention for Patents and Trademarks, the Berne Convention for Copyright, the Rome Convention for Performers' Rights, and the IPA Treaty for chip designs. So if you qualify for protection under one of those conventions, you're generally considered a national for TRIPS purposes within the WTO system, even if your specific home country isn't in, say, the Berne Convention, as long as it's in the WTO.
Wow, okay, so it broadens the reach quite a bit, pulling people into the system via the WTO membership.
That's the intent, to make it inclusive within the trade framework.
Are there any loopholes, any situations where national treatment doesn't quite apply?
Good question. Article 3.4 does mention a few exceptions, like if older treaties allow for reciprocity, I'll treat your nationals well if you treat mine well. That can sometimes continue.
Okay.
And national treatment doesn't automatically cover rights that aren't actually specified in the TRIPS agreement itself.
Right, it only applies to what's covered by TRIPS.
Correct. And agreements that existed before the WTO generally get grandfathered in, provided they don't create unfair discrimination.
Okay, that lays a solid groundwork. Foundational principles clear. Let's maybe move into specific types of IP. Copyright seems like a good place to start, maybe those related rights too.
Sure, copyright. One interesting point in TRIPS is Article 11, which deals with rental rights.
Ah, yes, for software and movies, right?
Exactly. It says members have to give authors of computer programs and films the right to basically control the commercial rental of their stuff.
So they can say yes or no to Blockbuster, essentially, or, well, the modern equivalent.
Pretty much. It recognizes that if you have widespread, uncontrolled rentals, especially of digital things, it can seriously damage the value of the copyright. So creators need that control.
Yeah, easy copying could kill sales otherwise. Are there limits to that rental right?
A couple. For films, a country might not need to grant the right unless rentals are already leading to widespread copying that's really hurting the author's reproduction rights.
Okay, a sort of material harm test.
Kind of. For software, the rule doesn't apply if the program isn't the main thing being rented, like software embedded in a rented car's navigation system, maybe.
Right, incidental use. Got it. Now, we mentioned the Berne Convention earlier. How does that fit with TRIPS on copyright?
Berne is much older than TRIPS, and it lays down a lot of the fundamental international rules for protecting literary and artistic works. Article 3 of Berne sets out who's eligible. It's usually based on the author's nationality. Are they from a Berne Union country?
Or where the work was first published.
Or where it was first published, yes. If you meet those criteria, you generally get protection in all the other Berne member countries. It's like the bedrock layer of international copyright.
And what core rights does Berne guarantee that are important here?
Article 5 is key. It says that in Berne countries, other than the work's home country, authors get the rights that country gives its own citizens, plus the specific rights from the Berne Convention itself. And importantly, getting these rights doesn't depend on registering or anything. It's generally automatic. Protection is also independent of whether it's protected back home.
Automatic protection, that's significant.
Yeah.
And the basic right to copy reproduction, is that in Berne too?
Oh, absolutely. Article 9, authors have the exclusive right to authorize reproduction. There can be exceptions, but they have to be limited and can't unreasonably mess with the author's legitimate interests. That right is obviously central.
Definitely. Okay, what about those related rights? Performers, music producers, broadcasters.
Right. Those are mainly covered by the Rome Convention, which TRIPS also references. Articles 4 and 5 of Rome set up national treatment for performers and phonogram producers, record labels, basically.
Similar principle to copyright, then.
Yes. Eligibility is based on things like nationality, or where the performance happened, or where the recording was made or published. So under TRIPS, these related rights holders also benefit from national treatment across WTO members.
Okay, comprehensive cover for creative works. Let's switch to trademarks. I saw TRIPS says you can't have compulsory licensing for trademarks. That sounds important for brands.
It is, yeah. Article 21 is very clear on that. Trademark owners have the exclusive right to use their marks, and they can sell or assign the trademark, even separately from the business itself. It protects the brand's identity.
Underscores how vital trademarks are. Okay, then there are geographical indications, or GIs. This is about linking products to places, like you said, Champagne.
Exactly. Article 22.1 defines them. Identifiers showing goods come from a specific place, and crucially, that a particular quality, reputation, or characteristic is basically due to that origin.
It's about protecting that link.
It is. Think Scotch whiskey, Darjeeling tea, things like that.
So what protection does TRIP require for GIs?
Article 22.2 says members must provide legal ways for people to prevent the misuse of GIs. Like stopping someone from labeling wine as Napa Valley if it isn't from there, even if they technically say style of Napa Valley, but it's still misleading.
Preventing confusion and unfairness.
Right. It's about stopping unfair competition and making sure consumers aren't deceived about where products really come from.
This sounds a lot like older ideas in the Paris Convention about false labeling and unfair competition.
Spot on. Articles 10 and 10 bikes of the Paris Convention are directly relevant. They mandate protection against false indications of source and unfair competition generally, which definitely includes misusing GIs.
And what if a company registers a trademark in its home country? Does that help them get protection abroad?
Yes, the Paris Convention helps here too. Article 6, Quinquis A.1. It basically says a trademark properly registered in its country of origin should generally be accepted for filing and protection, as is in other Paris Union countries.
Streamlining things for international brands.
Exactly. There are some exceptions, like if it clashes with an existing right in the other country or is deceptive there, but the principle is recognition of the home registration.
Makes sense. Okay, let's tackle the big one. Patents. Cornerstone of innovation, right? What are the general TRIPS rules here?
Yes, patents are huge. Article 27 sets the main stage. It says patent protection must be available for pretty much any invention, product, or process in all fields of technology.
As long as it meets certain criteria.
Right. It has to be new. involve an inventive step, meaning it's not obvious to someone skilled in the field and be capable of industrial application or useful.
That's the standard hurdle.
That's the standard. TRIPS does allow countries to exclude certain things, like methods for treating humans or animals, or plants and animals themselves, but they still have to provide protection for plant varieties, either through patents or a special system, or both.
And I saw that footnote saying inventive step can mean non-obvious, and industrial application can mean useful. Just different terms for the same idea.
Pretty much. It acknowledges different legal traditions might phrase it slightly differently, but the underlying standard rewarding real innovation should be consistent.
Okay. Now, what if someone wants to use a patented invention but can't get the owner's permission? Are there situations where that's allowed? Compulsory license.
Ah, yes. Article 31 covers other uses without authorization, often called compulsory licensing. It's a complex area with strict conditions.
Like what?
Well, generally, you have to have tried and failed to get a voluntary license on reasonable commercial terms first. The use is usually limited mainly to supplying the domestic market.
Okay.
There are exceptions for emergencies or to remedy anti-competitive practices. And importantly, even if a compulsory license is granted, the patent holder still has to get paid adequate compensation.
So it's not a free-for-all. It's a safety valve, maybe?
That's a way to think of it, balancing inventor rights with public interest needs.
How long does patent protection last under TRIPS?
Minimum term is 20 years, measured from the filing date of the application. Article 33 sets that, gives a decent window to commercialize the invention.
20 years. Okay. And if a patent is for a process, like a way of manufacturing something, how do you prove someone's infringing? Seems hard to see inside their factory.
It can be tricky. Article 34 helps here. In infringement lawsuits over a process patent, if the end product is identical, the court can actually order the defendant, the alleged infringer, to prove their process is different.
Ah, shifting the burden of proof.
In certain circumstances, yes. It makes enforcing process patents more feasible for the rights holder.
And now back to the Paris Convention again. I assume it has key patent rules that TRIPS builds on.
Absolutely. Article 4 of Paris establishes the crucial right of priority.
What's that?
If you file a patent application in one Paris Union country, you get a period, usually 12 months, to file in other member countries, and those later applications are treated as if they were filed on the same date as the first one.
Wow, okay. Buys you time to go international.
Exactly. It's incredibly important for seeking global protection.
I also remember Paris saying, you can't refuse a patent just because selling the product is restricted locally?
Yes, Article 4 Quater. A country can't deny or kill a patent just because, say, there are safety regulations limiting the sale of the patented drug. The patent right is separate from market approval.
Interesting distinction.
And Article 5A.2 of Paris also confirms countries can grant compulsory licenses to prevent abuses, like if the patent owner just sits on the patent and doesn't use it in that country, failure to work.
Okay, that covers patents well. What about those specialized chip designs, layout designs, or typographies?
Right, a niche but vital area for electronics. Article 35 of TRIPS says members must protect these, referencing specific parts of the IP treaty, plus some extra TRIPS rules.
So a dedicated framework, what's illegal to do with them without permission?
Article 36 lists the no-nos. Importing, selling, or distributing a protected layout design for commercial purposes. Same goes for an integrated circuit that incorporates the protected design.
And even products containing those chips.
Yes, if the product contains an unlawfully reproduced layout design, it tries to cover the supply chain.
How long does that protection last?
Article 38 gives the details. Basically at least 10 years. If registration is required, it's 10 years from filing or first commercial use, whichever is earlier. If no registration, it's 10 years from first commercial use anywhere.
10 years. Okay. Now, trade secrets, undisclosed information, protecting that secret formula or customer list.
Precisely. Article 39 links this back to preventing unfair competition under Article 10d of the Paris Convention. It says members have to protect undisclosed info according to specific conditions.
And what are those conditions? What makes information protectable as a trade secret?
Paragraph 2 of Article 39 lays out 3 things. 1, it has to actually be secret, not generally known or easily figured out.
Okay.
2, it has to have commercial value because it's secret.
Right.
And 3, the person who legally controls it must have taken reasonable steps to keep it secret. If all that's met, others can't acquire, use, or disclose it in ways that are contrary to honest commercial practices.
Like industrial espionage or bribing an employee.
Exactly, those kinds of things.
And there was also something about protecting data submitted to governments. For drug approvals, maybe?
Yes, paragraph 3. This is about protecting test data, often very expensive to generate, that companies submit to get marketing approval for pharmaceuticals or agricultural chemicals.
Right.
Members have to protect this data against unfair commercial use by competitors, and also against disclosure, unless it's needed to protect the public or other steps are taken to prevent unfair use. It incentivizes the costly R&D needed for these products.
Makes sense. You invest millions generating data. You don't want competitors just using it for free. Okay, we've covered the rights. But how are they enforced across borders? That sounds like the really hard part.
It is critical. Rights without effective enforcement are, well, not worth much. Part 3 of TRIPS is all about enforcement.
What's the main idea?
Article 41.1 sets the general obligation. Members must ensure enforcement procedures exist in their laws to allow effective action against infringement. This includes remedies that are quick enough to matter and strong enough to deter future infringement.
But not so cumbersome they block legitimate trade.
Exactly. Article 41.1 also stresses that procedures shouldn't create barriers to legitimate trade, and there need to be safeguards against abuse.
Okay.
Article 41.2 adds that procedures must be fair, equitable, not overly complicated or costly, and without unreasonable delays. Efficiency and fairness are key.
What specific tools do courts have? You hear about injunctions.
Right. Article 50 covers provisional measures. These are temporary court orders to stop an infringement before it happens or right when it starts, or to preserve evidence.
Can they do that without telling the other side first? Like a surprise raid?
Yes, what's called ex parte measures are possible, especially if there's urgency like the infringer might disappear or evidence might be destroyed. It's a powerful tool for immediate action.
Sounds open to abuse, though, if someone gets shut down based on a one-sided story.
Definitely a risk. So there are safeguards. Article 50.3 says the person asking for the order has to provide decent evidence they own the right and infringement is happening or about to happen. They might also have to put up money, a security deposit, to compensate the defendant if the order turns out to be wrong.
Ah, insurance against wrongful action.
Sort of. And if an ex parte order is granted, the other side has to be notified quickly afterwards and gets the right to a review, a hearing, to decide if the order should stay, be changed, or be canceled. Due process is built in.
Okay, that balances it a bit. What about stopping fakes at the border? Customs involvement.
Yes, crucial role for customs. Article 51 requires members to have procedures allowing rights holders who suspect counterfeit trademark goods or pirated copyright goods are about to be imported to ask customs to stop them.
Suspend their release.
Exactly. Article 52 says the rights holder needs to provide enough evidence of infringement and a good description of the goods so customs can actually spot them.
Makes sense. Can they stop tiny amounts? Like one fake watch in someone's luggage?
Article 60 provides an exception there. Members can exclude small quantities of non-commercial goods in personal luggage or small mail shipments. Practicality dictates you don't stop every tourist.
All right, de minimis imports. What about serious large-scale counterfeiting or piracy? Are there criminal penalties?
Yes. Article 61 mandates criminal procedures and penalties. At a minimum, this applies to willful trademark counterfeiting and copyright piracy done on a commercial scale.
Jail time. Fines.
Penalties should include imprisonment and and/or fines that are hefty enough to actually deter people, similar to other serious crimes.
Okay.
Remedies can also include seizing and destroying the fakes and the equipment used to make them. Countries can choose to apply criminal penalties to other types of willful commercial-scale IP infringement, too.
So a whole enforcement toolkit, courts, customs, criminal law. What if countries disagree about whether someone is following these TRIPS rules? Disputes between governments.
Good question. Those disputes go through the WTO's main dispute settlement system, the Dispute Settlement Understanding, or DSU. TRIPS doesn't have its own separate court.
So it uses the general WTO process.
Correct. And under the DSU, Article 3, if one country thinks another is violating TRIPS, that's generally considered prima facie evidence that the first country's benefits under the agreement are being harmed.
And the first step is talking.
Always. Article 4 of the DSU pushes for consultations first. Countries are supposed to talk in good faith, explain the problem, cite the rules, and try to find a solution before escalating to a formal dispute panel.
Negotiation before litigation, basically.
That's the idea.
Now, TRIP also has these transitional arrangements, especially for developing countries, right?
Yeah.
Why was that needed?
Yes, Article 65. It recognized that implementing all these IP rules could be challenging technically and financially for developing countries and those shifting to market economies.
So they got extra time?
Pretty much. There was a general one-year delay for everyone. But developing countries got an extra 4 years, so 5 total, to apply most TRIPS provisions, except the core non-discrimination ones.
Okay.
Countries transitioning to market economies could also get similar flexibility.
And wasn't there an even longer delay for patents in some areas for developing countries?
Correct. Article 65.4 allowed developing countries that didn't have product patent protection in certain fields, like pharmaceuticals perhaps, when TRIPS kicked off, to delay applying those specific patent rules for another 5 years on top.
Giving them time to adjust their industries and laws.
Exactly. Time to build capacity.
But they couldn't use that extra time to weaken their existing IP laws, could they?
No, that's a key condition in Article 65.5. Any changes made during the transition period couldn't result in less consistency with TRIPS. It was meant to be a glide path towards compliance, not away from it.
A one-way street, gradually implemented. Okay, now let's broaden out. We focused heavily on TRIPS, but our sources also mention GATS and GATT 1994. How do services and goods trade rules connect to IP? Let's start with GATT services.
Right, the General Agreement on Trade and Services. It brought services into the multilateral trading system in 95. All WTO members are part of it.
And it covers different ways services are traded.
Yes. Article Y.2 lists 4 modes of supply. Mode 1 is cross-border, like online consulting. Mode 2 is consumption abroad tourism, basically.
Right.
Mode 3 is commercial presence, a foreign company setting up an office or subsidiary. And Mode 4 is temporary movement of people, like an architect going abroad for a project.
How does IP fit into those service modes?
Well, think about it. Cross-border supply often involves transmitting copyrighted digital content, software, entertainment.
Right.
Commercial presence might involve franchising, which relies heavily on trademarks and business method know-how, potentially trade secrets. And consultants moving abroad, Mode 4, are trading on their knowledge, which might be protected by copyright or even involve patented methods. So IP is often embedded in the service being traded.
GATS also has these specific commitments countries make. How does that work? Is it different from goods trade?
Very different. Unlike JT for goods, where national treatment generally applies everywhere, under GATS, the big obligations like market access, Article 16, and national treatment, Articles of 7, only apply if a country has specifically listed that service sector in its schedule of commitments.
So it's a la carte?
Kind of. And even then, they can put limitations on their commitments, like we'll allow foreign banks, Mode 3, but only 3 new licenses per year. This sector-by-sector approach means IP protection related to services can vary depending on these specific commitments.
What about the MFN principle, treating all trading partners equally? Does that apply across the board in services?
Generally, yes. Article 2 requires MFN treatment. You should treat services and suppliers from one WTO member no less favorably than those from any other. But countries were allowed to list specific exemptions to MFN when GATT started, so there can be exceptions where preferential treatment is allowed for certain partners in certain sectors.
Okay. And GATS recognizes countries still need to regulate services, right? For safety or quality.
Absolutely. Articles 8 and 6 and the intro text make that clear. GATS aims for liberalization, but respects the right to regulate for public policy objectives, consumer protection, quality standards, etc.
So it's a balance.
It is. The catch is that regulations should be, objective, transparent, not more burdensome than necessary, and shouldn't discriminate unfairly between foreign and domestic suppliers. Regulation shouldn't be disguised protectionism.
Got it. Okay, let's quickly touch on GATT 1994, the Agreement for Trade in Goods. How does IP factor in there?
Well, GATT's main focus is tariffs and non-tariff barriers on physical goods. Its core principles are MFN, Article 1, and national treatment for internal taxes and regulations, Article 3.
So mostly about making sure imported goods aren't unfairly taxed or regulated compared to domestic ones.
Exactly. But this can impact IP-intensive goods. If a country slapped a huge discriminatory tax only on imported CDs or patented machines, that could violate GATT's national treatment rule.
So it indirectly protects trade in IP goods.
It can, yes. Also, GATT has rules on anti-dumping, Article 6, selling goods unfairly cheaply, and safeguards, Article 19, for sudden import surges causing injury.
Could those be used against IP-infringing goods?
Theoretically, maybe. If dumped counterfeit goods are injuring a domestic industry making legitimate ones, maybe anti-dumping could apply. Or if a flood of pirated software disks harms local producers.
But it's not the main tool.
No. TRIPS provides the direct IP enforcement tools. GATT is more about fair trade and legitimate goods, though its principles can sometimes touch on IP-related trade issues.
Okay. And just to wrap up the structure, these agreements, TRIPS, GATS, GATT, can they be updated, reviewed, amended?
Yes, they're designed to be living documents. Article 71 of TRIPS specifically mandates reviews by the TRIPS Council.
Okay.
GATT has amendment procedures in its Article XX, and GATT's Article 9X commits members to ongoing rounds of negotiations to further liberalize services trade, which inherently involves review and potential updates. So, yes, mechanisms exist for evolution.
So, not set in stone forever. Good to know.
Wow, okay. This has been quite the journey through the landscape of international IP. Let's try and pull the main threads together. Yeah, let's recap. We've seen how agreements like TRIPS, often building on older ones like Berne and Paris, create these minimum standards for protecting and enforcing IP globally.
Across most trading nations.
Right. And core principles like national treatment and MFN are there to ensure fairness, stop discrimination.
We looked at the specifics: copyright, trademarks, GIs, patents, designs, trade secrets, the whole range.
And crucially, the enforcement side. How countries are supposed to provide tools, courts, customs, even criminal penalties to actually make these rights meaningful.
Plus the WTO dispute settlement system for government-to-government issues.
We also noted the flexibilities, the transitional periods, especially for developing countries, recognizing implementation takes time and resources.
And we touched on how GATS for services and GATT for goods, while distinct, definitely interact with IP-related trade.
So overall, it's this complex web of rules aiming to facilitate trade and innovation by providing predictable protection for intellectual creations.
It really highlights how intertwined IP is with global commerce. These frameworks are, well, vital plumbing for the modern economy.
Which leads us to maybe a final thought for listeners to chew on.
Go for it.
Given how fast technology changes, how information flows globally, how well do these agreements, negotiated some time ago now, actually balance the need to protect IP, to incentivize creators and innovators, with the equally important goal of ensuring access to knowledge, technology, and culture for everyone, especially in developing nations? Is that balance right? How effectively do these frameworks foster both trade and sustainable development in today's world?
It's an ongoing debate, a constantly shifting challenge.
Definitely food for thought. Where is that line, and are we drawing it in the right place? If this dive has piqued your interest, we really do encourage you to look at the original agreements: TRIPS, GATS, GATT, Berne, Paris. The details are fascinating.
Thanks for joining us on the Deep Dive.